Hello friends and welcome to Sarat Chandra IAS Academy where your dreams are our mission. This is Yatharth here and today we are starting our polity series as we are already just a second. Okay, so we are starting our polity series. We have already finished a few segments of the question paper, namely geography, environment and economy. So now it's time to move on to parts polity. And in this lecture, we'll be dealing with a very important topic, due process of the law. So let's see what was the question that was asked in the prelims. What are the additional concepts that we should know about in this context and for the next year? I'll also tell you what is the relation of this person with this question. Okay, so let's move forward. So let's move towards the question. It's asking in essence, just a second. Okay, so it's asking in essence, what does due process of law mean? All right. So it's asking us about this, something known as due process of law. Due process of law. So it has four terms: due, process, of, and law. All right, so it's asking basically that what does this mean? Is giving the option such as the principle of natural justice. Natural justice is prakritik nyaya. That means what is just according to the nature. Okay. Second thing is the procedure established by the law. The procedure established by the law. Third thing is fair application of the law. Fair application. And the fourth option is equality before law. So we shall discuss all these options and figure out what should be our answer towards this question. It's not a subjective question. Some coaching centers and various students have claimed that the nature of this question is subjective, but this is not a subjective question. Once we arrive to the conclusion and through the knowledge, we'll know that what is actually the meaning of due process of law. All right, so let's move forward one by one. Okay, this is one more question that we are going to attempt in the next lecture. What is the chief purpose of constitution in a country? Sometimes what happens when we come home after the attempting the questions, we just see the answer, we realize that okay, yes, this is the correct answer, but we often miss these all other options. We don't know why these are incorrect and why we got confused in the examination. Why these options all of a sudden became so confusing in the examination, and as soon as we see the answer key or explanation, we are like, yes, this was always the answer, just that I couldn't realize it. All right, so we'll see what happens in the exam also regarding these questions. This question also we'll attempt in the next lectures. Okay, let's proceed one by one, and in this lecture just get done with the due process of law. Okay, so the first thing first, this article must be known about, Article 21. The protection of life and personal liberty. No person shall be deprived of his life. That means he will not be punished in such a manner that he dies as a result of that, or capital punishment or hanging basically. All right, or deprived of his personal liberty, that means arrested. Except according to the procedure established by law. All right, that means both of these things must be lawful. This fundamental right is available to every person, citizen and foreigners alike. Now, what is the issue here is that in this article, the defining thing is as per the procedure established by law. procedure by law. Now in let's say a fascist country or a communal country like this, North Korea, this person is a dictator here. It's a dictatorship. Now he makes a law that any person who keeps a haircut like this, except from him, can be arrested. So it's as per a law that anybody can be arrested like this. So it's according to the procedure established by the law. All right, yes. But is it fair to arrest anybody just because they kept a haircut like this? It's unfair. So it is procedure established by law, yes, correct. But is it fair? No. That means, is it justice? No. So what do fundamental rights proffer? They proffer justice. Let's now come towards India. All right. Let's say the Home Ministry makes law through the parliament. They make a law that such and such person can be arrested on doing unlawful activities. So there will be a procedure established by law. But now, to make it lawful, to make it just, that upon doing something normal or something which is okay, nobody should be arrested, even if any law has a procedure towards that. So what will we follow? We'll follow the due process of law. So what is this? Let us see. So due process law is a fundamental principle. Principle means rule. It's not mentioned in the constitution, nor it is a right. It is a principle of the Indian Constitution enshrined in Article 21. It guarantees that no person shall be deprived of their life, liberty, or property without following the procedure established by the law. This means that the government must follow fair and just procedures when it takes away somebody's rights. Now, this fair and just is not actually mentioned. Just what is mentioned? That should follow the law. Now, who will guarantee that the law is fair and just? So, this principle will guarantee. Principle of due process of law. Alright, so there are two main aspects of the due process. One is the procedural due process and substantive due process. The procedural due process requires that the government follow fair procedures when it takes away someone's rights. This includes things like providing notice of the deprivation, giving the person a chance to be heard, and ensuring that the decision is made by a neutral decision maker. So this will be the correct procedure. That the person is intimated that you are going to be arrested in such a such case. If let's say he is not a criminal, it's let's say a civil right or anything. Second thing is he must be informed of what is being snatched from him, what rights, what are his rights still in the custody or during the trial. And another thing, what must be ascertained, right to be heard, as well as the decision is made by a neutral body or person. The arrested person also has the right to be silent and not to produce any evidence against themselves. Alright, so these are the rights of a person, and they are ascertained by following the procedural due process of the law. That the procedure should be followed and it should be correct. The judicial examination of whether the fundamental elements of the legislations are consistent with the Constitution is known as substantive due process. This means that the laws cannot be arbitrary or unreasonable, and as per the Constitution, the laws must also be consistent with the principle of fundamental fairness. This is basically a question of how back can we go. That means when we take basic things of life, such as a subject of maths, then we have to follow certain premises, such as 1 plus 1 is equal to 2. Now, this is a basic or fundamental premise. This is a basic concept and a reality that is established and accepted universally. Anybody in the world cannot deny that this is correct, because upon this concept, the whole system of mathematics relies. This tells that anything, when integrated of its 2 units, it will make or it will get double in size. Alright, but there's no proof of this. This is just a universally accepted fact. This is how back we can go when it comes to maths. When it comes to other things, such as the idea of justice, we can go back to the Constitution. We can go back to the legislative. And we can see whether these follow a principle of the nature. Nature is from where we learn everything, even the justice. When the wind blows, the stronger trees will remain intact. The shorter ones or the thinner ones may fall. Now this is nature. This is a principle of the nature. This is an observation which we make in nature. So it gives us the idea of justice. That upon being faced by a strong force, those who are weak in the society cannot face it. And that's why it is just to, let's say, give them some sort of support. So this is something we made the idea from nature. And this is basically natural justice. Okay. Now let's come back. So the judicial examination of whether the fundamental elements of the legislations are consistent with the Constitution is known as substantive due process. This means that the laws cannot be arbitrary or unreasonable, and they should be natural. The laws must also be consistent with the principle of fundamental fairness, that is basically natural justice. Due process is an essential safeguard against government tyranny. What is tyranny? It means the persecution of anybody by making us arbitrary law. See, this is tyranny. He is a tyrant. He will make a law tomorrow that anybody who is watching TV will be arrested. Anybody who is a Christian in his country will be arrested. Okay, this is arbitrary law. This is not according to the fundamental fairness or any natural justice. That's why he is a tyrant, and this is government tyranny. Okay, in India we don't follow these type of things. We are a democracy. There is natural justice. There is equality before law. There is a sense of fundamental fairness. Alright. Now let's come. The due process consists of all these things, such as a right to a fair trial, the right to be free from unreasonable searches and seizures, the right to be free from self-incrimination. That means giving out some evidence which can lead to somebody's, let's say, them being declared culprit in any case. The right to due process in administrative proceedings. The Supreme Court has interpreted the due process clause of the Constitution in a number of different ways over the years. That means in various different cases. But now let us understand the term, what is its origin. So what is the origin of due process of law? The term due process is derived from the Latin phrase debitur processus legis, which translates to process of law is due. It emphasizes that individuals are entitled to fair treatment, and the government must follow established rules and procedures when depriving a person of their rights. The idea is that no one should be subjected to arbitrary is without any pattern, or capricious actions by the government. and there should be a fair and just legal framework in place to protect the rights of any individual. Now let's come back to the due process of law. So what is the due meaning here? Due meaning that owed or required. And the process of law refers to the legal procedures, steps or methods that must be followed in any legal action of governmental decision that affects the individual's life, liberty or property. That means, seeing it simply, just a second, okay. That means if the government action requires somebody or something to be arrested or snatched the rights to be taken away, that means this action can only take place via a due process of law. Without this, it's not possible. This due process must be procedural as well as substantive. That means it must follow the procedure and it must not be arbitrary, unreasonable, and also must follow the fundamental principle of justice and natural justice. Alright, it says that action, okay, you can take, but the process of law is due. This is the due process of law. Okay. So in the Indian Constitution, due process of law has thus broken out of the golden triangle formed by Article 14, 19 and 21. According to judicial interpretations, Article 21's reference to procedure established by law has been judicially interpreted as due process of law. The theory of basic structure is analogous to the substantive due process in law of the USA. That means the origin of the due process of law is in the American Constitution. In India, Maneka Gandhi versus Union of India 1978 case, a very famous case, which included the idea of non-arbitrariness, served as the precedent for what is known as due process of law. The court ruled that no law created to deny somebody their life and personal freedom in accordance with Article 21 should be arbitrary, unfair or unreasonable. On the other hand, Article 14 of the Indian Constitution guarantees the right to equality before the law and equal protection of the laws to all persons. It prohibits discrimination on the grounds of religion, race, caste, sex, or place of birth. That means the option 1, equality before law, is actually Article 14. That means upon being tried by the law, all must be treated equally. Whether they are poor, rich, old, young, belong to a certain strata, CM of India, PM of India, whoever. Alright, it's basically equally before law. Whatever their religion is, whatever their race is, whatever their caste is, whether they are a male or a female, does not matter. In front of law, all are equal. Article 19 of the Indian Constitution, on the other hand, guarantees certain freedoms to all citizens, such as the freedom of speech and expression, the freedom to assemble peacefully, the freedom to form associations or unions, the freedom to move freely through the country, and the freedom to practice any profession or carry on any trade, business, or occupation. So Article 19 is mostly about the freedom, a positive freedom. Let's now come to the Article 21. It guarantees the right to life and personal liberty. And all person, it ensures that no person shall be deprived of their life except according to the procedure established by the law. And again, as per the due process of law. Due process must be both procedural as well as substantive. Alright. Some important case such as A.K. Gopalan versus State of Madras. So he was jailed in Madras jail under the Preventive Detention Act through a writ petition under Article 32. The petitioner challenged the act's constitutionality on the ground that it violated freedom of movement and personal liberty. In this case, the SC held that literal interpretation of the words procedure established by law and declared the Preventive Detention Act to be constitutional and further elaborated the difference between the doctrine of due process and the procedure established by law. So this is a case in a site. The court said this is clear from the drafting committee of the Constitution in respect of Article 21 that they actually wanted to use the term due process of law, but dropped it in favor of procedure established by law. This expression must mean procedure prescribed by the laws of the state. Now, for the laws, they are not arbitrary and random, so it must be ascertained by the legislative. Thus, the doctrine of due process was not enforced in India. As the A.K. Gopalan case became a precedent, it was overruled finally in the following case. Most important case, Maneka Gandhi versus Union of India case. So, the petitioner was a generalist whose passport was issued under Passport Act of 1967. Maneka Gandhi received a letter from the regional passport officer on July 7, in which she was ordered to relinquish her passport in the public interest under Section 10 of the Act. Within 7 days of receiving the letter, she inquired the reasons for impounding her passport. The authorities, on the other hand, said the reasons should not be revealed in the interest of the general public. In response, the petitioner filed a writ petition under Article 32, stating that Section 10 of the Act was unconstitutional, citing violation of fundamental rights against 14, 19, and 21. The authorities, on the other hand, said that the reasons should not be revealed in the interest of general public again. In response, the petitioner filed a writ petition, so we have already seen this. The court declared the act in question to be violative in nature. Alright, so this established this due process of law. It emphasized the reasonability behind the law to be important, not just the procedure. This is the due process of law, that the procedure is important, yes, correct. But the procedure is not the foremost thing. It's not the foremost thing. What's foremost is the reasonableness. It must be reasonable. Right. So with regards to Article 21, the court held, even though the phrase under Article 21 is procedure established by law, the procedure must be free from arbitrariness and irrationality. Alright, thus establishing the rationality in India is procedure established by law plus the procedure should be fair and just and not arbitrary. So this is the final conclusion that we can make from the due process of law. Now you must be able to understand it completely. That the due process means first, procedure must be followed completely and correctly, and it must be fair, just, and in a negative sense, not arbitrary and not unreasonable. Alright, so this is the meaning of due process of law. Let's now solve the question. Just a second. Okay, let's move to the question. This was the question R. Okay, so what does the due process of law mean? So does it mean the principle of natural justice? It does not mean the principle of natural justice, because there is a procedural feature. The procedure should also be correct, not only just. The procedure established by the law. So this is a whole different term. Alright, this is not the same as the due process of law. The procedure established by law is correctly mentioned in Article 21. And it says that the procedure only should be correct. Alright. By mixing these both options, we get the third option, fair application of the law. So this is correct. Application of the law is procedural application of the law, and fair means substantive. So this is correct. Equality before law, this is a whole different thing mentioned in Article 14. So this is not the due process of law. That's why our option third is correct. So third option is correct. So this was today's lecture. I hope you liked this lecture a lot and gained a lot of knowledge. This is again Yatharth here. Signing off. I'll see you in the next video. Have a very good day. Keep studying and be bright.